The House Committee on Oversight will come to order. Would the clerk please take attendance?
Chair DeBoyer.
Here.
Representatives Bierlein. Meerman. Paquette. Cara. Bruck. Green. Regis. Shriver. Wolford. Miller. Pohutsky. Conlon. McDonald. Menser. Cerniglu. Wagella. Mr. Chair, you have a quorum.
Thank you, clerk. Representative Carr moves to approve the minutes of the March 18th meeting. Hearing no objections, they are approved. Next agenda item today, we're going to be adopting additional committee rules. What those additional committee rules are is, as everyone is aware, this committee has subpoena power granted by the House of Representatives, and these are the issued rules that will govern the process of issuing a subpoena, issuing the authority to do depositions, the process by which that would be done. Both council has had access and a month of review of these rules. So if there's any questions, I'd be happy to take them. Yep. Representative Pohutsky.
Thank you, Mr. Chair. My question is around Rule 4D consultation. I'm glad that there's going to be consultation around deposition notices or deposition subpoenas, but is there any requirement for notice around non-deposition subpoenas, like the one that we're going to be voting on today?
Are you asking specifically notice?
So, I mean, for example, we are going to be taking up a subpoena today. I have not seen it. It doesn't sound like anyone over on this side has seen it.
Yeah, so to answer that.
Yeah.
So what we're actually going to do today is we're going to authorize the issuance of one. And within the rules, what that will allow for is there's certain things that have to be explained here, publicly, discussed between us, if you so choose, that comply with the requirements of the subpoena. So we won't issue the subpoena. We'll authorize the issuance, and then that subpoena, when it's put together, will be available to all members to see that subpoena.
Okay.
Of the nuts and bolts of what it is.
Great,
Yes.
thank you. So are we going to be discussing what may or may not be in the subpoena that will eventually be
The
issued
specific
today?
one we're doing today, yes.
Great, thank you so much.
Yep. Representative Miller.
Yes. So will we be voting on the special rules?
Yes.
Okay,
Yes.
so I do have some questions here. So under confidentiality, how will the committee navigate protecting confidentiality of shared information within the committee? That's one question.
Yep.
Subpoena, as currently written, House Rule 36-1 prohibits subcommittees from being granted subpoena power. Will subpoena power be extended to these subcommittees? And under depositions, what is the purpose of the deposition by oversight, since depositions are traditionally used for pending litigation between parties to a lawsuit? And how will the deposition be used? And when, I read in these committee rules that you can have an attorney present, but if your attorney says don't answer that, the chair can overrule that, correct?
Sure.
Okay, so help me understand your experience, your expertise and knowledge, because the way I look at it, it should be a very fair and impartial process. So that being said, is there any judiciary review, or will you be the determining factor whether someone answers that? And if they don't answer that, what's the ramifications? What's the punishment or, the consequence of not answering? And could there be a resolution that says, hey, we're going to remove you from office? So
Remove who from office?
remove whoever is testifying, if it's
oh.
a state or, an elected official. And then in the rules, it also states that there will be testimony taken, but I don't see where that's by a certified court reporter or a transcriptionist. So how is that fair and impartial?
There would be.
Let's see.
There would be a certified court reporter.
Okay, well, it doesn't state that in
Yeah,
there.
there would be.
Okay,
So,
well,
does it not?
again, it doesn't state
Okay,
that, so.
fair enough.
Those are a few
Yep.
of my concerns.
Yep.
I
So-
have more, though.
So, yeah, so with regard to an individual who chooses to not answer a question, and even if there's a ruling that, no, you should answer that question, their constitutional rights still maintain. Meaning, if they would like to assert privilege or incrimination potentially, all those constitutional rights that are afforded them still apply, right? So, the matter of them answering, not answering, ruling against them, telling them to answer, they still have the right to exercise their individual constitutional rights if they choose to refuse to answer a question. Right?
Okay,
Now,
so-
your question is sanctions, or
Right,
would we,
yeah. Can they, yeah.
a resolution to remove someone from office or
Right,
something
yeah,
like that.
because they refused to answer, or their attorney told them
Yeah,
not to.
so
Chair
under the
DeBoyer,
Constitution.
point of order, it actually specifically states in Part H that if someone refuses to answer, they may be subject to sanction by the House of Representatives.
But they do not remove their privilege if they do not want to answer something because they believe could be incriminating to themselves, they can still exercise that right. They can still exercise that right.
Without sanctions.
Potentially without sanctions.
Okay.
If it's just an egregious disregard for the authority of this body, which by the way includes all members, that's a very different scenario than someone exercising their constitutional provision to not have to make a statement that could potentially incriminate them, right? That's a big difference between those two things. And I would argue that the role of oversight is to look at the operations of government, make determinations based on statements from people who work in government, from people who do not work with government, who work in a fashion of service from government. That is the role of oversight. So if people choose to not answer questions, that's fine. But remember, there's going to be counsel. The person being questioned can have counsel. There will be counsel from the Republican. There will be counsel from the Democrat. Everyone will be there to have this discussion. It's not going to be just me. There's going to be additional members there. The person being deposed has the right to have counsel with them to advise them on their rights and positions. You asked a question with regard to a resolution to remove someone from office. The Constitution of the state of Michigan provides some very clear roles by which people can be removed from office, and a resolution by the Oversight Committee is not one of them.
Okay. If I may.
Yep, sure.
Aren't depositions are a tool that is normally used outside the courtroom where there's pending litigation before a court? Help me understand
sure.
why we, as a committee, would
Sure.
hold that power, why
Sure.
we would need to do that.
Yeah, a deposition is a fact-finding exercise. So when there is an issue that needs to be dealt with, I mean, unless you as members would like to sit here and bring every person that is going to be deposed in, by the way, we would be here for 5 days a week.
But don't we already have that power through public hearing?
Certainly we do.
Okay.
But depositions give the ability for the individual to be interviewed, to find fact, of which that fact will be used in any investigation, any determination we are trying to find as the Oversight Committee. That's the purpose of a deposition. And yes, is it used in civil cases? Certainly it is. But depositions are used in every type of case. They're not just used in civil cases. They're used in every case to find fact.
Right, but these circumstances, the deposition removes the process from public view, does it not?
Only if there's information that is deemed to be a confidential. But remember, there's going to be representation from both sides there, right?
All right, thank you.
Yep. Representative Wagala. Did I get it right that time?
Getting closer, Wigella. I think it was close enough. First, I just want to ask if things are sent. I heard you mention these were sent a month ago. This is maybe an issue on our end, but I got these like yesterday. So if you could send them to the whole committee too, that would be beneficial to me.
Sure.
That being said, I do have questions about Rule 3, Section B. It says subpoenas may be issued upon the motion of the chair or subcommittee chair. It's not lost upon me that excludes anyone from the minority party from motioning for subpoenas. I would love to have that privilege as a committee member if we're going to have that power. And then in Rule 4, Section E, it says no one may be present at depositions except members authorized by the chair of the committee. My major concern with these rules is, as a rank and file member of the Oversight Committee, through both of those pathways, not having the ability to potentially sit on a deposition because that's determined by the chair, and then also not be able to make the same motions as other members of the committee. Just looking for some explanation on why the rules were structured that way.
Yep. A deposition is going to have representation from both sides. But it's not an open dialogue with the committee as a whole during the deposition, right? But those depositions will be transcribed. They will be done by a certified court recorder or reporter, depending on how it's done, video or otherwise, and will be available, provided there's nothing in there that is deemed by both sides to be of a confidential nature that shouldn't be shared. That would be the exception, obviously. But again, there's representatives from both sides there that are going to make that discussion and determination, if that makes sense.
It works, but anyway, I think I can be loud enough, teacher voice here. Would there be any open discussion on expanding the ability to motion is something, I feel like a motion could be killed pretty easily, especially by the majority party. So having the ability to motion as a minority party shouldn't be that, I guess, threatening. I would love to see a change in the rules. If that's something that the majority party is open.
I would say that moving forward, all of these rules at any time are amendable,
Okay.
which can be a discussion we can continue to have. Yep. Yep. I'm sorry, Representative Cerniglu.
Sorry, thank you. So I just wanted to, I have several questions as well, and if it's okay with you, I want to go step by step.
Sure.
Because that way we can, make sure, I'm understanding the answers correctly. So Representative Miller asked about the confidentiality and how that would be handled in protecting confidentiality. I mean, just as an example, if someone's health information might be involved. So how will you protect the confidentiality? Is there a process, or like what will that look like?
So remember that the process is going to involve both sides in the discussion. If there's a request for confidentiality, that will be discussed internally with those members. Again, no one is going to lose their constitutional protections. So nor are they going to lose their HIPAA protections.
Sure,
Those
but
are
my
all
question is, who
viable.
will determine ultimately whether the confidentiality is granted? Because that, those privileges and whatnot are kind of legal issues, and it doesn't sound like there will be someone who is qualified to make a legal ruling on
Right,
confidentiality
so the discussion
involved.
will be made between the attorney from the client, the attorneys from the Republican side, the attorneys from the Democratic side, and the chair, the duly appointed and elected chair of the House Oversight
Sure, I
Committee.
understand that, but even a duly appointed chair, be they Democrat or be they Republican, is not a judge and does not have legal authority
We're
to
not
make
making a
that.
judgment. We're not making a judgment on someone. We're making a determination if it fits into confidentiality or it does not. That's what both lawyers are going to be there to demonstrate.
Okay, so the lawyers will be advising you as the
Absolutely.
chair?
Yes,
And-
both sides will have it will be a discussion. Yes.
Okay. I understand the answer there. So also, just to confirm, subcommittee chairs can make motions to issue subpoenas, but the subcommittee itself cannot issue the subpoena. It has to be
Correct.
issued by this larger body.
This larger body.
Just want to make sure we're, getting the clear answers on those questions. And it sounds like you answered the question about who will receive a copy of the deposition transcription, that it will be publicly available unless there has been some determination of confidentiality or privilege.
Correct.
Okay. And then it sounds like the purpose for the depositions would be simply for saving time?
Well, that could be one of them,
Okay.
certainly.
Are there other criteria for determining what is eligible for a deposition versus coming into the full committee? Like what types of issues would necessitate that aside from just time constraints? Is there certain criteria for things that would warrant?
Ultimately, at the end, it's the vote of this oversight committee that makes a determination if someone's going to be deposed
So
or
the
not.
whole oversight committee will be voting on what we can, what you
If
will
there would
do
be
the
a deposition
depositions
or not of an
for?
individual, yes.
Okay.
Yes.
We did this, it's publicly available. I guess for the transcripts, when they're completed, will they be automatically sent to members, or will we have to request?
As a general statement, I would say they would be, but realize that there's also potential in deposition that criminal matters could arise that we're unaware of.
Right, so
right?
that would be a.
There's
those
circumstances,
would
and that
be
discussion would be had
confidential then.
between the lawyers
Okay.
to lay out, hey, this could be a criminal matter, don't you think we should maybe refer this instead of make it a public matter? And that would be entirely determined between the conversation between the
Okay,
legal
and
counsels.
also just understanding the depositions, I understand that, not everyone will be able to ask questions at the depositions. It looks like only certain people will be allowed to actually be present. Is that accurate, or is the public, would this
No.
be treated like open to the public?
No, depositions are not a public forum. Depositions are a closed door with representation from both parties.
Correct, but they're normally used in a legal setting, not in a,
They're-
so I want to
No,
understand.
they're normally used in oversight committees also.
I want to understand what this oversight committee has
Yep.
in mind for depositions.
Yep.
And are there any safeguards for any type of abuses of the deposition process, not only now in this legislature, but in future legislatures? And have we looked at what those could possibly be?
When you ask safeguards, you are a member of the safeguard. You are a member of the oversight committee.
Sure, but with the understanding that, at times, these types of processes can be used politically, and,
Sure.
with the, understanding that even if every single Democrat in this committee
Sure.
votes no, you
Sure.
can issue a subpoena
Sure.
to anyone you want. And on the flip side, if it were the other way around and there were a Democrat
Sure.
had a majority, my question is just simply, are there safeguards that can be used, not only for, this term now, but just going forward, and that maybe other oversight committees have used and you have used as a model for your own
Ultimately, the
rules?
vote of this oversight committee is that safeguard. And frankly, if you use the word political, the people and your constituents will make a decision whether it's political or whether it's warranted. And I have been very clear since I have been appointed the chair of the Oversight Committee that this is going to be done in a manner that is appropriate, professional, not for political fodder. And that's a judgment that the citizens of Michigan are going to have to make. But the Oversight Committee is the safeguard. We make a determination if a deposition is required or if a subpoena should be authorized. That is what our job is. That is our job.
Thank you for your response.
Representative Bahutsky.
Thank you, Mr. Chair. Sorry to go back to this, but just a slight point of clarification regarding representation during depositions, and with the acknowledgement that there is a chance that we, as members of the committee, will not be able to be present during any of those depositions. There's also nothing in the rules that guarantees that our legal counsel will be there during a deposition either. So while I, respect you and take you at your word, there are also instances where we may not be, as members, we may not be the deciding factor either. There are, leadership decisions and things like that. So what guarantee do we have that if we can't be there, we will have anybody in that room that can relay to us what may have happened, pending, confidentiality and things like that?
Just one second, Representative Klodsky. So under Deposition Authority Rule 4, F, who may question? A deposition shall be conducted by counsel designated by the chair of the committee upon consultation with the minority vice chair. The chair shall designate one attorney from the majority Office of Legal Counsel and one attorney from the minority's Office of Legal Counsel.
I'm
Those
looking
are
at,
the two questioners during the deposition. Both of those questioners are present during those questions.
but I'm looking at E, about who will be able to attend, and those two things do not mesh. So it seems like E should reflect F, or,
No, attendance would be people who are attending the deposition, not the people who are taking the deposition. The lawyers, the deposition is the process by which lawyers depose a witness.
I'm familiar with what a deposition is, thank you.
But for the clarity of people who are listening, it matters.
Well, I mean, it's worth noting that we're not live streaming right now. It says that the video was removed by the uploader, so I'm not sure who's watching right
Yeah,
now,
okay.
past who's in
Well,
this room.
That's unfortunate. The attendees are the individuals who are there
Okay,
observing the deposition. That's the difference between the two. So there will absolutely be minority and majority counsel at the deposition.
great. Thank you
Yes.
for that clarification.
Yep. Representative McDonald.
Good morning, Chair. I have a question about the confidential information, Rule 2.
Rule 2, did you say? I'm sorry.
Yes. Or is it 2.0? Confidential information. Now, we're talking a lot about the deposition subpoenas, but this is not limited to those cases, right? The idea of this new rule is that people are entitled to receive confidential information. It gives a lot of authority to the chair and the speaker to decide what they can disclose to, as it says, may share and disclose confidential information among themselves and other specific designees authorized by the chair or speaker of the House. So I don't know how much confidentiality that protects, but my question is, if somebody were to breach this confidentiality in an inappropriate way, what would be the penalty?
Do you want to touch on that? How would you address the? Yeah. You know what, we're going to go at ease. We'll have a discussion, and I will give you the best answer that we have here. We're at ease. Site will come back to order. So just to address the matter of how do we manage an episode of someone violating confidentiality? I want to make sure that's your question, right?
Yes.
Okay. The individuals who could be violating confidentiality essentially could be, obviously, any member of here, us, right? And as elected representatives, I would say that that's a violation of one of our simple standards, right, of confidentiality. That is much more of an ethics issue that we would reside in. But with regard to non-elected or non-representatives or non-members, it could be the lawyers, right, that are involved. It could be a staff member, right? I mean, I want to make sure we're on the same thought here.
Yep.
It could be a staff member that we have shared information due to the process of the job, right? And those individuals, they work for the House of Representatives. And as applies today with certain confidentiality requirements, all of those positions have a myriad of potential sanctions from disciplinary action to potentially, depending on how egregious, right, termination of their job. So the violation of confidentiality for non-members, meaning us, will reside with the same disciplinary action that would reside with any violation of House rule outside behaviors that go directly against expectations.
Don't you think it should be clear what the penalties are? I mean, that's very vague. It feels like, wow, we're going to have this rule too, and that's going to take care of the whole issue of confidentiality, except it doesn't do anything.
Do we have spelled out penalties for any violation of any of our rules, House
Well,
rules?
I'm just asking because it's like, seems pertinent to some of the things we're discussing right now, like the Department of State, where maybe there are some items that they don't want to submit because they are very, if the information got out, it could jeopardize our election integrity. So I think that's relevant, and we're saying that there's going to be confidentiality, but there's no penalty, there's no rules. It's just, there's confidentiality, but the chair and the speaker can give the information to whoever they please.
As they have expectation of confidentiality now with other matters that we deal with on a daily basis as members of the House.
I'm just not quite sure how Rule 2 does anything.
I appreciate that. Thank you.
Thank you.
Representative Wolford.
Thank you, Mr. Chair. Appreciate you. Non-elected people answer to the elected, the people. Oversight, definition, responsibility for a job or activity and for making sure that something is being done correctly. As an oversight member, wouldn't it make sense that we would want to have people answer questions that are before us? I've never heard people so concerned about people having to come in and answer questions. So how do we oversee something if we can't ask questions to the non-elected for the sake of the people, for the sake of $84 billion, for the sake of, my question is, what are we so worried about today? It should concern us if or when or why someone can't answer a question. Our citizens and our taxpayers deserve it. And potential abuse is why we're here today, so that we can answer to the people that put all of us in these chairs. So, political power, Article 1, Section 1, all political power is inherent in the people. Government is instituted for their equal benefits, security, and protection. So, Chair DeBoyer, thank you for the job that you're doing. Thank you for your leadership. And thank you for standing up for the citizens that pay taxes and that are looking for answers of potential waste, fraud, and abuse. God bless you. Thank you, sir.
Sorry. Representative Miller.
Thank you. Yes, thank you, Chair, for
Yep.
putting in the work on this. And I don't dispute not having the ability or the right to ask questions. Of course, that's important, but it's more important to do it in a fair and equitable manner. Decisions on privilege should be decided, I feel, by an impartial person, and maybe that could look like a arbitrator brought in, because we need to be as fair as possible. Something else I wanted to add, that under subpoena 3.0, it says, you can administer oaths unless already designated through a resolution or specified and approved by a resolution. So my question is, who can authorize oaths? Would that be you?
Yes.
Okay. And then also on being served, there's a 3-day notice, correct?
3-day notice on being served?
Yeah, so so once you serve and tell them that they need to appear, what is
Sorry,
the
yeah.
timeframe? I thought it was 3 days. I could be wrong.
It could be whatever the pleasure of the committee is for them to testify. Are you speaking testifying?
Testifying.
Deposition?
Yes.
Yeah.
What's the time frame?
Yeah, whatever.
If it's 3 days, it's not enough
No,
time.
right,
I feel
correct.
you need at least
And-
5,
and-
but I
and
don't
that-
know
yeah.
where it's stated in here what that exactly is.
That's again an argument of reasonableness, right? And I believe that reasonableness should prevail. Additionally, as I mentioned earlier, all constitutional rights of an individual still apply. So lawyers can move to squash subpoenas. It can end up at a judge. This is, like, you're not forfeiting your constitutional rights because a subpoena is issued to you. That's not what this is. If in the legal process, they still have all of their legal exercising of their rights beyond what the authority of the Oversight Committee is.
So this could go to court?
Absolutely.
Okay, thank you for that
Absolutely,
clarification.
yes.
That's very important
Yes,
to know.
yes.
And so what would that exactly look like? And how long would that take? And what would be the circumstances that it would go to court?
I can't comment on to the circumstances for which it would go to court, but there's a rather specific process on the motion filing of a case and a motion and a desire out of a judge and a timeline for service and a timeline for answer and a timeline for, that's a well-established statutory process.
So who decides if it goes to court or not? Can that be the attorneys?
Well, ultimately, it would be the attorneys that would file, right?
Okay, right?
And then it would be the judge that would make a determination on validity for moving forward.
Okay,
Yep.
thank you for
Yep.
that. I appreciate the work that
Absolutely.
you've done. I just want to make this as fair, like I said, and impartial, because it could be abused by any one person or one party for self-serving purposes
That
or
is the
political gains.
Yeah,
Thank
that
you
is
for
the
that.
beauty of the Oversight Committee. What our job is to look at the abuses of government on behalf of the people. Now, could that creep into this committee? Of course it could. But I would argue that if there's any integrity on this committee, that it will not creep into this committee. Our job is to prevent that kind of behavior in government.
I understand that, but I'm also hearing that there will be a judicial review
Sure.
as well,
Abs-
correct?
Potentially, if that's the desire
All
of the
right.
parties.
Thank
Yes.
you. I think there
Yes.
should be.
Absolutely.
Appreciate that.
Representative Bruck.
Thank you, Chair. I have a question. I know that within Michigan law, MCL Section 4.101, it does authorize the power of subpoenas for the state legislature to do. Obviously, this is the first time I've ever been on an oversight committee, as well as I think everyone here, and we haven't had a robust oversight committee here in Lansing, I think, for a long time, for too long. I guess, could you go through a little bit of the history of the oversight and the power subpoena? As obviously, this isn't the first time that it's in our law. There's been times in the past where we have had the ability and have subpoenaed and had that power to do that in order to get good people to testify in order to provide oversight for our state. Can you give some history or background on, in the past, when this has been used? And I guess, for our rules, special rules that we're adopting today, how they mesh with past rules?
Sure.
things of that nature. Thank you, Chair.
Yep. So, the last robust oversight committee would have been 2 or 3 terms ago, in which weekly, monthly, they held hearings and addressed issues that existed in government that may have been demonstrating a failure of the role of government. Since then, it's not been a robust oversight committee. I believe the last term there was 4 hearings, 3 or 4 hearings held. As far as the rules for oversight committees go, you know, there's myriads of different oversight committees from every state and entity in government. The rules that we have before us line up in principle with the oversight rules that exist at the federal body, that exist to a large degree in previous oversight committees that have been convened in the state of Michigan. And there's nothing in here that's gotcha politics. There's nothing in here that is designed to cause someone to have a distinct disadvantage beyond the obvious, which is the roles of the individuals that were elected by the citizens and put in those positions. That's the essential history and current circumstance on oversight, rules, and committee. Representative Menser.
Thanks, Chair. I just had a quick question about what criteria are you going to use to choose who from this entire committee gets to sit in on a you know, deposition or testimony? You know, I have a college degree and I graduated with a 3.98, if that helps.
That's fantastic, by the way. A couple years ago, right?
Yeah, just a few.
A couple years ago?
2009, actually. Took me a while.
I'm sorry? Yeah. Yeah. So essentially what the deposition will look like.
Who the people you
Right.
choose,
Yeah,
right?
right. So attendance at the deposition will be relatively limited because that's not by design. You want an individual that's being deposed to be comfortable answering their questions, right? The idea, I don't know if you've ever been in a deposition or not, I don't know.
I haven't committed any crimes.
Well, you can be in a deposition and not commit a crime. I mean, that's, yeah, being a criminal has nothing to do with being deposed. The environment you want in a deposition is not an adversarial environment. You want an honest environment that allows the person that's being deposed to feel comfortable answering their questions. That's what you want in a deposition.
Sure, of course, I agree 100%.
Because at the end of the day, we want the truth.
I agree 100%.
Right.
How are you going to choose those people?
We'll make a determination on a case-by-case, depending on the circumstance, depending on who we're deposing, depending on what the topic is. But essentially, it's going to be the lawyers from both of our respective
Right.
parties, the deponent, the individual being questioned, and their lawyer, if they so choose to bring one. They may not, but if they would like to, they certainly can, right? That's who essentially is going to be there.
Okay. Not quite what I was looking for, but I can live with it.
Let me go one. Representative Rodriguez.
Good morning. Thank you, Mr. Chair. I appreciate all your leadership on this issue. And just, can we clarify, what was the date where these rules were set out to the committee members?
They were sent to the lawyers because the lawyers were the ones that worked back and forth on the legalese of these.
Yep.
On March 19th.
March 19th. When were they set out to the committee members?
I don't know.
I got them last night.
I don't know. I don't know. I don't know.
Last night.
Yeah, I don't
Okay.
know when the Democrat lawyers shared them with.
Okay, so
membership.
it was their lawyer's responsibility to share these rules? Okay, so, I appreciate the rules. At this time, I don't have any questions left because I think everything possibly that could have been asked has been asked. But I do appreciate your straightforwardness and your transparency with the rules and what the goal and our insight for oversight is this term. Because all of our goals should be an efficient operating government for the people of Michigan. So if people are brought in to ask questions, I think that as a body, I think that would benefit all of us. So I just appreciate your leadership and answering my question. Thank you.
Representative Miller, you still?
Yes. So I wanted to ask, how does the deposition process, how does that comply with the Open Meetings Act?
Legal proceedings are not
There's no violations, right?
correct.
Correct?
Correct. Legal proceedings, House oversight, depositions are not governed under the Open Meetings Act because it's not you're not convening an elected body or, for that matter, a politically appointed body. It's not covered under the Open Meetings Act.
So if you have a quorum in this deposition, that makes a meeting, correct? So if it's closed session.
Which, to address that, there would never be a quorum.
I see.
in a
Okay,
deposition.
Thank you for that.
Yes.
Thank you for the
Yes.
clarification.
Absolutely. Representative Cerniglu.
I just wanted to confirm, it appears that someone who's being deposed can have their own attorney aside from like the caucus, attorney. I just want to confirm that that's an accurate
I want to make sure I heard you right.
interpretation.
They can have?
Yeah, is
Yes.
that an accurate interpretation of the rule? I just want to
Yes.
clarify that for my own
Yes, it
understanding.
is. They can have
Okay,
their own.
thank you.
Yes, absolutely. Representative Conlon.
Thank you, Mr. Chair. As to Representative Menser's question earlier, do you foresee when you're choosing members to be a part of a deposition, and I appreciate a smaller group for that process, always having at least one member of each party there?
I cannot say that that would be the case every time, but I think that that would be at least a reasonable discussion to have when we know we're going to be that there's going to be a deposition held. I think that would be a reasonable conversation between the legal counsels, because the truth is everybody sitting on this board has different values and different life experiences, right? That understands circumstances, maybe understands one thing better than something else, that they may be a valuable observant to that process in the discussion with their counsel, to make sure we do ask the questions that we need to ask to get the answers we want to get just the truth, ultimately. So there's no absolute there, but it's a reasonable thing, I believe. Yes,
Thank you.
yes. Representative Bierlein.
Thank you, Mr. Chair. I want to just kind of clarify one piece of all of this. We're always going to ask for this information first, right? So like if we're going to subpoena or we're going, if we're going to subpoena a person to come to the committee or documentation to the committee, it will be after we have asked for it and then not been given. Is that accurate?
That is 100% accurate. There is a due diligence process that is required. You have to ask for the information. Frankly, in my opinion, you probably should follow up with the question of the information. And as I said, when this committee convened initially, my hope is that we never have to issue a subpoena, because my hope is that the individuals in which we are charged with overseeing will cooperate in the best interest of the state of Michigan and the people of the state of Michigan, and provide information to this committee that's relevant to us doing our job. Unfortunately, we've seen in the past that that's not necessarily the truth, that they don't comply willingly. That's unfortunate. But yes, Representative Bierlein, the due diligence is required. You must request it. Again, I would argue that you should follow up on the questioning for that information before you get to the point that you issue a subpoena. Thank you. Representative Wagala.
First off, thank you for being patient and answering these questions. I would have loved to give feedback earlier, but Rule 5, the very last rule that we have in the packet, the chair of the committee may waive or modify any of the requirements of this rule in order to facilitate cooperation. Have a little, I don't know, heartburn on the language in that, the way I read that based on anything in Rule 5, that would,
Tell me again what section you were just in?
Rule 5, very last page, Section 4.
Section 4.
So the way I'm reading that, anything in Rule 5 would essentially could be subject to change by you, yourself, the chair of the committee, or modified. Concerns about what are if that happens, making sure that we're notified in the committee of that rule change, and
Yep.
then there's a lot of leeway there, so looking to see that. And, I'm hyper aware that we're in a very, especially these days, it feels that democracy is very fragile, and that rules are only as good as the people who are willing to actually follow them. So there's a lot, I think, in all of this of we're trusting our chair to follow the rules. But with this in particular, there's a lot of leeway. So just looking to see what your thoughts are.
I would say to you that your concern, number one, would be valid. It's a valid concern. And number two, that in the event that were to be necessary, it would most certainly be shared with this committee. Again, I would say that my hope is that that's never a necessary action. But I do believe, in the interest of the transparency of what we do and why we're doing it, that most certainly that would be brought to this committee and discussed with you. Yes. Representative Cara.
Thank you, Mr. Chair, and thank you for all your work on this. I think this document at large looks very good, and I'm very happy with where it's going. I do have just two thoughts with it. The idea of having the ability to motion for subpoena powers, if that is just left to chairs and subcommittee chairs, I would think minority vice chairs possibly should probably get to have that ability as well. It's worth considering. It's just my 2 cents. Worth considering at least. And then also for Section 5, subsection 4, we were just talking about there, perhaps instead of just the chair alone, perhaps that could be something that could be done by motion of the full committee. I don't know if those two things might possibly be considered. I think this document is very good. Those are just, after hearing this feedback from the committee, those are my two thoughts. I just thought I'd share those with you. Thank you, Mr. Chair.
Thank you. Or Representative Potsky.
Thank you, Mr. Chair, and thank you for your patience. I really do want us to be able to utilize these tools, so I just want to make sure that I'm clear on everything. So I'm sorry, but going back to the first
okay.
question I asked you about
okay.
the process around subpoenas,
Yep.
if I'm understanding it correctly, you had sort of indicated like a two-step process. Like we discuss the issuance and then they're written up essentially, right? That two-step process doesn't appear to be reflected anywhere in the rules?
So what we grant is we grant the authorization of the subpoena, right? So then, remember, there's certain requirements that when we discuss the subpoena here, that when a motion is made, that motion has to have certain information, right? So that motion's made, that certain information is in that motion. The subpoena then is derived based on that information, because remember, this is the official record. And that information can be obviously brought to you guys, meaning you'll understand what is literally contained in that subpoena, right?
Sure.
But additionally, the legal counsel has the right to say, whoa, whoa, whoa. Okay, here's what your subpoena says, but here's what the authorized subpoena was, right? So there's that deliberative discussion or argument that can be made, and it goes to what Vice Chair Miller had said, which is that could end up very simply ending up in a motion to squash a subpoena that ends up at a circuit court. And they're not complying with the rules here, right?
Sure. But we're only going to be taking one vote as a committee as to whether or not a subpoena moves forward.
Right, but as we move forward on a subpoena, right, although we're not in the court of law, we are in a quasi-oversight position, and so there are those judicial tenets, if you will, of the process, which says, does the subpoena comply with the motion?
Sure, and I guess that's what I'm getting at, is the actual motion. This can all be done verbally, correct?
Here, you mean?
Right.
Yes.
I guess my concern is, so, you know, when we talk about the documents requested from the Department of State, there was, when Representative Smith came before the committee, there was a little bit of back and forth, and I feel as though we left with a little bit of uncertainty about what the final formal request would be, right, in terms of some things that were deemed sensitive or security issues, things like that. I am concerned that I am going to be asked to vote on a subpoena and not be totally sure of what's going to be in it, because it's going to be a verbal thing that I will be hearing definitively for the first time as I vote on it. And I think that this is a very important tool, but legally speaking, this is a coercive motion that we are making against anybody, right? In this case, it's a State Department. And I think that that is an important thing, and in some cases is required. But I have concerns about the necessary deliberative nature of that, and the fact that and none of us, frankly, at least over on this side, will be seeing what we are voting on, unless we can write it down quickly enough.
Fair enough, and I understand what you're asking. You're voting on whether to authorize the subpoena or not. Once the subpoena is constructed, right, that becomes the process in which the council is involved, right?
Well, right, but with all due respect, my council isn't elected to represent the
No, but
90,000 people I am.
That's the tip, when a lawyer issues a subpoena or a subpoena is requested from other means other than a lawyer, it's authorized.
Mm-hmm.
It's not reviewed and authorized. The act is authorized, right? If a subpoena is issued that's outside the bounds, that is a problem, and it's dealt with by the lawyers. They make the argument that you were authorized to issue a subpoena under these tenets, which we would list, but you're not within those tenets. You're outside of those tenets. So therefore, your
Sure.
subpoena on its face is not valid.
I'm not debating the legal nature of this, because frankly, we are an extrajudicial body, right? And I'm fine with that. I am fine with us issuing subpoenas. That is a necessary thing that we have to do sometimes, and it's part of our job as oversight and a co-equal branch of government. My issue is my ability to do my job appropriately and to be able to go back and tell my constituents, I knew exactly what I was doing when we did it. And I frankly think that the process laid out here is just, it makes that very difficult, because we're not seeing any of that ahead of time. So I don't know right now what we are potentially going to be issuing in the subpoena, because the last time we had a conversation with the person requesting the information, it was not definitive by the time they left this room. And I just think that that could be a little bit, as simple as if there's consultation for depositions, including deposition subpoenas, why do we not have consultation for regular subpoenas not related to a deposition? I don't think that 3 days, especially if this is all something that's been asked for since November, which is an absurd amount of time for a request for some of these things, what difference 3 days makes so that we can be certain of what we're going to be approving in an issued subpoena. Sorry, that was obnoxious. Not the question, the hitting the microphone. I think my question was pretty solid.
Your concern is noted.
Thank you.
Yep. All right. So being no further discussion, we will move forward with the adoption of additional committee rules. Representative Bierlein moves to adopt the committee rules. Will the clerk please take the roll?
On the motion to adopt the additional proposed committee rules, Chair DeBoyer,
Yes.
Representatives Bierlein,
Yes.
Meerman,
Yes.
Paquette,
Yes.
Cara,
Yes.
Bruck, Green, Regis, Shriver, Wolford, Miller,
Pass.
Pahutsky,
Pass.
Conlon, McDonald, Menser, Cerniglu, Wagella. Mr. Chair, you have 9 yeas, 2 nays, and 5 pass. The motion prevails.
Next, we're going to consider the authorization to allow the chair to issue a subpoena. I would move that the House Oversight Committee authorize the chair of the committee to execute a subpoena. The information being sought is necessary to the work of the committee because election integrity is the utmost importance to the functioning of our republic form of government in the state of Michigan. And the Department of State has been unacceptably difficult in ensuring transparency regarding how the department is training local clerks to administer our state's elections. The House Oversight Committee exercises a vitally important role in providing legislative oversight over this function of the executive branch of government in our state. The Michigan House of Representatives has the right to know how Secretary of State Jocelyn Benson is instructing local election officials to conduct the elections within the state. Secretary Benson's refusal to provide the House Oversight Committee with basic training materials provided to local election officials indicates that the training provided does not comply with the Michigan election law. If the training did comply with the Michigan election law, Secretary Benson would not be withholding the documents from the House Oversight Committee. 2, previous efforts made to obtain the information being sought without the issuance of a subpoena are as follows. For a period of 4 months, Representative Schmidt sought to obtain records from the Department of State regarding training materials provided to local election officials. The department repeatedly refused to provide the records. On March 11, 2025, Representative Schmidt appeared before the Oversight Committee and requested that this committee subpoena the documents that the Department of State refused to provide to the House Elections Integrity Committee and to the Michigan House of Representatives. On March 12, 2025, the Oversight Committee chair sent a letter to the Department of State requesting a list of documents that the Department of State had refused to provide to Representative Schmidt. This letter gave a deadline of March 22, 2025 for the department's response. On March 19, 2025, the Department of State responded with a letter stating that the documents sought were limited to only those persons who, quote, need to know, unquote, what they contain. On April 4, 2025, the Oversight Committee chair sent another letter to the Department of State, again requesting the documents. That letter gave a deadline of April 14, 2025 for the department's response. The Department of State failed to provide all requested documents by the deadline of April 14, 2025. 3, the party to be subpoenaed is the Michigan Department of State and/or its relevant officers, employees, or agents, including Secretary of State Jocelyn Benson, and any records custodian of the Department of State. 4, a general description of the documents or other things to be produced are as follows. The documents and/or information requested by the Oversight Committee chair in his letter dated March 12, 2025 and April 4, 2025, which have not yet been provided by the Department of State. At this time, a subpoena only for the production of records is sought to be issued. With that information having been stated, I move to authorize the chair of the committee to execute a subpoena. Mr. Clerk, would you please take the roll?
You made the motion. On the motion for the chair to execute the subpoena, Chair DeBoyer,
Yes.
Representatives Bierlein. Yes. Meerman. Yes. Paquette. Yes. Kara. Yes. Bruck. Yay. Green. Regis. Yes. Shriver. Yay. Wolford. Yay. Miller.
Yes.
Pahutsky. Conlon. No. McDonald. No. Menser.
No.
Cerniglu.
No.
Wagella. No. Mr. Chair, you have 9 yeas, 6 nays, 1 pass. The motion prevails.
Thank you, Clerk. Next, we're going to be hearing from the Department of Environment, Great Lakes, and Energy as a follow-up to our previous meeting. If I may, I'd like to welcome Chief Deputy Director Aaron Keatley and Sydney Hart.
Good morning, Mr. Chairman, members of the committee.
Good morning. How are you guys?
We're good.
Thanks for being here.
Yes, thank you for having us. I'm Sydney Hart. I'm the Legislative Liaison for the Department of Environment, Great Lakes, and Energy. And here with me today, I have our Chief Deputy Director, Aaron Keatley, who's prepared some opening remarks. And then we'll be happy to take questions from the committee members. With that, I'll turn it over to Aaron.
Thank you, Sydney.
Chair DeBoer, Vice Chairs Bierlein and Miller, members of the committee, my name's Aaron Keatley. I serve as the Chief Deputy Director of the Michigan Department for Environment, Great Lakes, and Energy. On behalf of Director Ruse and the entire EGLE team, I'd like to thank you for the opportunity to be here today. Even though we were not invited to your March 11 and March 18 hearings, we did pay close attention to that dialogue. I'm here today to discuss EGLE's responsibilities, clarify how EGLE's decisions are made, and address concerns raised at those hearings. I welcome this dialogue, and I approach it both with humility and with clarity about EGLE's role. Let me begin by emphasizing one central point. EGLE's work is directed and defined by law. We do not operate based on philosophical preference. Our mission is grounded in statute, specifically the environmental laws enacted by this body, as well at times by Congress. These laws mandate how we manage permitting, compliance, remediation, and enforcement actions across our air, water, and land programs. In many areas, we implement federally delegated programs. Federal laws require that the state of Michigan enforce those federal standards at or above the national levels. If we fail to do so, we risk losing delegation, federal funding, and with it, the ability to tailor Michigan's environmental laws the way that Michigan needs. When EGLE takes actions, approving or denying permits, requiring cleanup, issuing violations, it is not overreach. It is not discretionary. It is the fulfillment of the legal obligations assigned to us by this body as well as by Congress. Environmental protection isn't a luxury, it's a safeguard. EGLE's work is essential to our future. The 1,500 dedicated EGLE employees understand this mission and they understand these responsibilities. Michigan is defined by its natural resources. From the Great Lakes to our inland waterways, wetlands, and forests, these resources are central to our public health, our economy, and our identity. Millions of Michiganders rely on groundwater for drinking water. Our lakes, streams support agriculture, tourism, fishing, and the quality of life. And the effects of pollution, whether they're from industrial discharges, chemical contamination, or air emissions, are often borne most heavily by those that don't have the ability to protect themselves. The legislature has long recognized this. That's why Michigan's environmental laws were created, to ensure that environmental quality is not left to market forces nor to voluntary action, but is actively protected through the law. To address some of the questions that were raised and concerns that were raised in your previous hearings, first, there's been a concern that EGLE has overstepped its authority. We respectfully disagree. Every permit decision, every enforcement action, and every regulatory update is made pursuant to statutory or regulatory authority, and these decisions are subject to administrative and judicial law. We are constantly reviewing our practices to ensure that they're legally sound and procedurally fair. Second, we recognize that tension often surrounds environmental regulations. From industry groups and developers, we hear concerns that EGLE is too rigid, too slow, or too demanding. At the same time, from residents, environmental advocates, and local leaders, we often hear that EGLE is too lenient, too differential to polluters, or too cautious in its environment or in its enforcement. These competing frustrations often arise in the same case, over the same property, and often on the same permit. This tension is not dysfunction. It's the nature of environmental law. It's what makes this job hard. Environmental regulation exists to balance competing priorities, economic development and environmental protection, public health and private investment, long-term sustainability, and short-term convenience. EGLE's job is not to pick sides. It is to implement the law fairly, transparently, and consistently, even when the outcome is unpopular for one side or the other. Third, we know that communication and public engagement are areas where we must continually improve. Environmental regulations are technical, and the process behind permitting and enforcement is not always easily understood. This can fuel frustration or mistrust, especially in communities with a history of pollution or underinvestment. I also want to emphasize something we believe this committee understands well. The environmental problems we face are real, and they're often urgent. We're dealing with aging infrastructure, legacy contamination, PFAS, flooding, stormwater overflow, increased pressure on our groundwater systems. These are not hypotheticals. They're measurable, they're documented, in many cases actionable under Michigan law. When the department responds to these challenges, we do so because the law requires it, and if we fail to act, the consequences are borne by the public. To be clear, EGLE's not above scrutiny. We welcome this committee's oversight. It is part of what keeps our work strong, transparent, and accountable. We are committed to continuously improving how we serve the people of Michigan. In closing, Michigan's natural resources are not only essential to our environment, they're central to our economy, to our health, and our way of life. And that is exactly why state and federal laws require agencies like EGLE to ensure those resources are protected. EGLE does this work with professionalism, with commitment to continuous improvement, and with respect to the roles of our partners in local government, the regulated community, the legislature, and the public. I look forward to your questions, and I look forward to continuing the opportunity to work with you on these issues. Thank you. If you don't, do you want to go ahead now, or do you want to sit?
No, I think that's it for our remarks. Thank you.
So we're going to take a couple quick questions, if you don't mind. Certainly. Representative Meerman.
Thank you, Chair. Thank you for being here. Appreciate this. It's an important part of, we the people sorting through things like this. And it's hard at times, but I think it's good. It's good to have hard discussions. For me, talking to many of the farmers and, asking if we had a tractor rally here, and the feedback I got was, I'm not sure I want to show up with my tractor there because I'm working with them currently, and I have a permit that I'm afraid might be delayed, or something might go wrong with that permit. I mean, just showing up here with a tractor, there was concern for that. And then even more so in testimony, like, for God's sakes, don't let anyone know we were talking. No, I cannot be public. Is that all unfounded? Like, where is that coming from? Why would they be so afraid of being public? And if we can't be public with our concerns as we the people, and I'm not talking about me, a legislator, I'm talking about people that are out there in our state of Michigan trying to do something in the state of Michigan, and they probably rightly so need a permit from the department, but for them to have so much fear, it really struck me, and I was very concerned. I realize I'm not giving you any details. I can't give you any names. But would you say that fear is completely unfounded? I mean, for them, it's coming from somewhere. It's genuine.
Like you, I don't know that I'm in a position where I can answer whether or not that fear is unfounded or not. I hope it is not. When we had a conversation earlier this year on the phone, I thought it was a good conversation, and I'll say the same thing now that I said to you then. If you have situations where you feel like somebody is being treated unjustly by our agency, or that they don't understand what is being required or why it is being required, call me. I don't want that to be the case. Like I said when I did my opening remarks, our agency has a really hard job to do. I know that you appreciate that, and you shared that in our conversation. And the way we navigate that is being clear about what is expected, why it's expected, what the problems we're trying to solve, and then what we need to do collectively together in order to get there in the way that is least invasive as possible. And if you ever have a situation where you feel like you have a constituent that doesn't feel like that is happening, I want to be part of that discussion and see if we can resolve that for you.
I've offered that, and they're saying, no, I don't want to be public. I'm afraid. Thank you.
Thank you, Representative. Representative Miller.
Thank you for being here today. A few years back, the governor issued an executive order to expedite the permitting process. And I believe, if I'm not mistaken, there was money set aside in the budget for that. So how has that been implemented, and how has this improved the process?
Yeah, that is a topic I would love to talk to this legislative body about more. We've really made some great improvements in our processes. I hope that as you engage with different industrial stakeholders, you will hear that echoed. I feel confident enough to be able to say that you should be able to hear that echoed right now. When I got here in 2018, which is when I came back to the state of Michigan and took this job, it was a difficult situation for what was then the DEQ, because over the years, there had been a lot of disinvestment in the agency. What that had resulted in was a lot of workload that had backed up and staff that were unable to achieve some of the outcomes. Through the last 6 years, there's been a lot of investments by this legislative body, by the governor, where we've been able to bring in more staff. Getting them up to speed has taken a little bit of time, but I've been able to see measurable outcomes in my water programs where 3 years running, we've reduced our backlog and decreased our time in terms of turnover. I've been able to see changes in our air quality program where we have fewer that are beyond our regulatory timeframes. We're making the steps that are needed within our processes to make ourselves more efficient. We've been moving our programs into a common electronic database where we can in order to create efficiencies as well as create opportunities for electronic submittals of permit applications. One of the biggest challenges around our timeframes with permits is the fact that we get a lot of deficient applications. Part of that is us needing to do a better job of explaining what needs to be submitted to us so we get good application on time. Part of it is the responsibility of the applicants to give us better information, but the amount of time that is wasted going back and forth between the agency and the applicant to get the information we need to make a decision causes more delays than anything else that I encounter. And to be able to create electronic tools that allow people to submit complete applications online in an efficient way is going to also decrease that likelihood that we have those kind of delays. But we're definitely making progress. Happy to answer any specific questions around programs you may like, but this is a good story and I'd like to talk to you more about it.
So if I may ask a follow-up.
Sure.
So you said you brought on more staffing with the amended budget money. So how many people did you hire? Because when I had issues when I was the chair of ag and we were trying to get to the bottom of that, we were told it was lack of staffing, but you're saying now that you hired people. So what does that look like? How many additional staff did you hire?
Yeah, I didn't know you would be asking that question. I don't have those specific numbers for it. I'm happy to share them with you. What I can say is we have roughly 100 different permitting types that we issue within our agency. Of course, you spread the staff that we have been received across all those programs. You get bumps in different places, and we try to prioritize those additional people in places that had the greatest need. One thing that has happened that is frustrating for not just us, but also for the regulated community and the consulting community who's also experienced the same thing, we've gone through that wave of generational retirements that have hit at the same time while we have been trying to restaff up. And so that has slowed down our progress in being able to build additional capacity within our program. Plus, we are taking people that had expertise of 25, 30 years and replacing it with people that have expertise of none and having to build them up. But again, the results are starting to show. I'm happy to talk to you about them, but those are some of the thought processes that we're doing as we apply it, and I'd be happy to give you those numbers.
Thank you.
Representative Bierlein.
Thank you, Mr. Chair, and thank you for coming in. We do appreciate the conversation. I represent a relatively rural district, a lot of agriculture, a lot of septic tanks, and I think for the better part of my adult life, we've always been told we are the problem. It's your septic tank that's polluting the groundwater. It's the farm field that's getting into the drains, into the ditches, and into the lake. And just the other day when we had a lot of rain, one of the local cities discharged 5,000 gallons of sewage, and with the note on the public notices, don't worry, we're still in compliance. I think that's part of the struggle here, is people don't understand, why is that allowed? But you want me to have a site inspection on my septic moving forward, those kinds of things. So I appreciate having this conversation moving forward. I just want to give you some context. You did mention everything you guys are doing, you're operating within the bounds of what the legislative boundaries have been set. And one of those things that's recently was brought up to me in office hours was some folks who do both residential and commercial septic fields. Like I said, we don't have city water and sewer everywhere. They have said that they can't get permitted to do a lot of these small-scale commercial. So you're adding a bathroom to a facility. It's under 1,000 gallons. It's supposed to be permitted by the local health department, and they can't get permits because the local health department was told by EGLE that you're not allowed to do that anymore. And the law clearly states that on those residential, or those commercials from 1,000 to 6,000 a day, that's the local health department. And so when I've asked my local person, the local health department people, hey, can we start talking about this? They don't want to have the conversation because they're afraid they're going to lose more permitting authority by EGLE. So I think these are the questions that we really need to find solutions to, not just, we need solutions. So I hope that we can continue this conversation moving forward. And I hope you guys understand where we're coming from. These are what our residents are telling us. They are afraid to testify in a public body committee because they're afraid of retaliation in their permitting processes. So I thank you for being here, and I just wanted to make sure you understood the context of what we're trying to accomplish.
Thank you, sir. Representative Cara.
Thank you, Mr. Chair. Similar to what Representative Beerline and Representative Meerman brought up, if somebody's seeking to get permission or a permit on their property for something, I've heard stories of somebody from EGLE saying that when they're going back and forth and disputing that circumstance, just a specific example, it's just saying E. coli levels on the ground, and they have these abilities to threaten them on something else and say you can get a citation for this if you're not in compliance with that. And that type of intimidation and threat level that the people from our communities are experiencing, not only just simply about whether or not they're going to come and testify, but in just trying to do something on their property and then having that type of threat and intimidation from EGLE. And having a peace and a sense that they can do what they want on their property would sure be nice. I mean, if we're going to have a process, it'd be nice to make it more efficient. I do appreciate your comments about maybe they could fill out the applications better and EGLE could do a better job from your end. But the intimidation end, I don't think has any home in this process. If you could give me feedback on what your thoughts are on that.
Yeah, I mean, intimidation's obviously come up a few times here this morning, and like I said, I hope that's not the case. And if it is, you have my license to come to me directly, bypass my staff, and work with me on these issues to make sure that that's not happening. And if it is happening in a way that we think is inappropriate, I'll deal with it. Our team has a really hard job, and I don't want to say that as a matter of rhetoric, but as a matter of fact. I mean, we are asked by you all, by the federal Congress, to take away individual rights and to make decisions that should be meaningful and appropriate to benefit the whole. That does not come without a great responsibility. And so I can understand where people would push back when they are asked to make changes. I get where people may be frustrated because they feel like they can't use their land in the way they want. I live on the Grand River. I would love to do things on that river differently than I can so I can fish better and have better access to my resource that's in my backyard. I don't get that right because when I do that, I infringe on other people's rights to also utilize that resource. And so that is the crossroads our team is often involved in, and we have to be thoughtful about how we ask them to do that work. But definitely, if there's ever a feeling of retaliation, that is not appropriate nor necessary in order to be able to accomplish our goals.
And if I could add to that really quickly, to provide a little bit of context from my conversations with staff. I know you mentioned like some of the comments received by staff about potential violations and things come off as like intimidation tactics. And I think from our staff's perspective, in some cases, they feel that it's actually them trying to be helpful, right? Like, we want to avoid this situation, and so this is how we would recommend that you do it. This would result in a violation, this would not result in a violation. And so in some cases, maybe it's not delivered in the correct way. I do think that most of our staff have good intentions about trying to redirect the project and find an alternative that ultimately reaches the goal of the applicant.
Statistically, one of the interesting things that I've found over my career, I've been doing this for 30 years. I did a whole career down in the state of Kentucky and led the agency down there before I retired. And it's no different here in Michigan than it is in Kentucky. Statistically, one of the things we have been able to show is that when staff go out and they do their oversight responsibility, just like this body does its oversight responsibility of us, when we do identify violations or we identify problems, usually we will address those verbally where we can. If they're significant or mandated by federal law, we will put them down in writing and issue them as a citation, as a violation notice. But all that document does, while it feels threatening to individuals, is describe what the expectation is, what they can do to remedy that expectation, and what the timeline for getting that done is in order for it not to result in additional problems. Of the violation notices that we issue, only about 10% of those end up going to any type of what we call escalated enforcement, which means is we removed it out of the hands of the district office because we're not getting the resolution we need in a timely manner. We're sending it up to Lansing to teams that specialize in trying to get resolution. And so only about 10% of those violation notices end up in that escalated enforcement process. Of those, only about 10% of those result in a penalty. And of those, most of them are resolved through a agreement between us and the party that had the violation. And so only 10% of those end up in court. So you're literally looking at 0.1% of the actual citations we issue that end up in any formal legal proceedings at all, and only about 1% that end up with any type of penalty. And mathematically, that shows throughout the agency's efforts. That's just a reflection, not because I'm trying to make a big deal out of the numbers, but rather to show you the progressive process that we try to identify and solve problems with our team. Our goal is not to plunge somebody into an enforcement action and penalize them. Our goal is to correct the problem because, again, the problems are real. When you talk about whether or not we've got sewage that's getting into our streams, they're real. We do not want that to happen. In order to get there, we need a pathway to make that happen. Some of it is through financial support. Some of it is through enforcement and oversight. Some of it is through just basic permitting and investment in order to be able to get better technologies to get those problems so they don't occur in the first place. But that is the spirit by which we're trying to approach these problems.
Representative Paquette.
Thank you. Thank you for being here. I don't want to pile on. I hear plenty of things from my constituents as well. I do want to note a positive thing that I heard last week from a Cass County treasurer. She was mentioning that we had a blighted gas station, and you guys were there quickly to help. You guys took care of the whole deal, which was phenomenal. So I want to mention that. But it is on us, especially with regard to criticism. We all get it. Some of it valid, more valid than other pieces, but it's on us also to connect those dots. So I appreciate your openness to facilitate good connections with our constituents and to get grounded in the truth. So thank you, and find some common goals. So appreciate you being here.
Thank you.
Representative McDonald.
Thank you, Mr. Chair. At our last committee meeting, we had a lot of testimony about the Fremont digester, and I know there hasn't been an opportunity to address some of the statements made about that. One of the things I'm interested in, and if this is irrelevant, you can just explain yourself, but my understanding is that they went from having a lot of solid digestate, and that switched over to liquid digestate, and that actually is the reason that there was much more interest in groundwater contamination. Could you explain that? Because I don't think that was clearly explained in that committee hearing.
Yeah, there were a lot of things that were said in the last couple of committee meetings that, in fairness, I probably would have loved to have been there and tried to correct the record a little bit. I made a conscious choice that I'm not going to be here to try to, correct people when they're not here to also explain themselves. However, what I can say is this was a really complicated situation for us. We do not have many commercial digesters in the state. We do have digesters. EGLE supports digesters, and they can be extremely helpful for us as we work on our energy portfolio, as well as basic savings to our communities. For example, there's digesters at wastewater treatment plants where they use the energy that they generate to power the wastewater treatment plant. We want that to happen. This commercial digester was unique for us in the sense that it took a lot of different types of materials. It was easy to talk about it being food waste. It wasn't all food waste, right? A digester will basically consume anything that's carbon-based and generate energy from it. We have a strange regulatory construct that the statute had laid out, which allows people to work in what is called an ag use exemption, as long as those have agricultural purposes and it meets certain criteria. Those rules changed halfway through the game for this industry. And with revisions to Part 115, it was a legislative change that happened. Basically, it identified that if there is liquid waste, then digesters, by law in Part 115, have 4 basic options in terms of how they can manage that waste. They can either treat it on site and discharge it to a creek, which in this case that facility couldn't do. They could collect it and send it off by truck to a treatment plant. They could pipe it to a treatment plant. Neither of those means were economically feasible for that company. Or they could do what their only alternative remaining was, and that is land apply it in a way that is consistent with that particular land and how it can manage the flow of the waste that's there. This facility did not apparently qualify for being able to classify its material as a fertilizer. I've been told by MDARD that it probably had too low of nutrient value, that it had too many extra constituents because of the types of materials that they brought in. For example, we've got information since that showed that they can take industrial detergents, that they were able to take cellulose-based insulation, and the results from their lagoons show contaminants in it that you wouldn't expect from food waste. So we had PFAS in it, for example. We had heavy metals in it. And so when you apply that to farmlands, and they were utilizing hundreds of different farm fields in order to be able to put the volume of waste that they were generating, when you apply that to farmlands, those farms then have to deal with soil toxicity. We have to worry about groundwater. We have to worry about surface runoff. And trying to reach an agreement with that company on a permit that they could afford because they were having financial stresses and they knew that additional requirements on them was going to put them in a bad spot, made it really difficult. I've got no disrespect for that company. I did not, I was very, very active trying to work directly with them. Met with Bill Caesar, their president, many times, trying to explain what we were trying to do, why we were trying to get there, and what our legal limitations were. And it resulted in a way that didn't support them on their side. So that's all I'm planning on saying about that particular thing at this point, but it was a difficult situation.
I think there's some clarity needed
Sure.
really quick. Are you saying that you have documented proof that they were taking things beyond food waste?
Yeah.
Because what you just said was there was things that could have been taken, and then you said based on the testing of the lagoon, it had PFAS and heavy metals.
Yeah.
Right? So then did you assume that they must have taken those things if those things were in the lagoon?
No, we get limited reports from those facilities on what they're accepting. So I knew that they were taking a lot of animal waste, for example, direct from dairy farms and others. Sir?
I'm trying to get some information so I
Sure.
can understand this, because this is a very huge thing. Does a wastewater treatment facility treat for PFAS?
Do they treat for PFAS?
Treat for PFAS.
Yeah, the treatment technologies that are utilized by our systems have different effects on PFAS. So PFAS, One of the best ways we found for reducing PFAS at wastewater treatment plants is to apply treatment at the upstream industries that discharge it to the wastewater treatment plant. So we've had wastewater plants that used to have very, very high levels that now, because we've been working with their upstream industries to
Right.
put technologies in place like activated carbon to reduce it.
Sure, but that's the
Yep.
incoming.
That's the incoming.
Do they actively treat for PFAS in the wastewater treatment facility?
Depending on the technologies utilized in different wastewater treatment plants, and they all have different recipes,
Sure.
if you will, in
Yep.
terms of how it does.
Yep.
Some have different effects. The way that we manage PFAS coming out of the back end of a wastewater treatment plant, one is they have the requirement to not discharge PFAS levels above water quality standards out of their actual discharge pipe.
Right.
The second thing is the biosolids that they have that may have PFAS levels in, they all sample it, and based on their sample results, we're able to determine whether or not their levels are safe to be able to put on agricultural fields, whether they have to be used differently, or they need to go to landfill.
Do wastewater facilities treat for heavy metals?
Again, yes, the way
They do.
that the plants work is you try to separate the solids from the liquids.
Right.
And then you manage those two waste streams in two different ways. So by concentrating the metals, for example, into the solids, it allows you then to send those to a landfill or manage them appropriately. Doesn't mean that they're eliminated from the waste stream, but we keep them from going to a destination that's not compatible with that particular waste.
Okay, so I just want to make sure I heard you, because they were certainly taking non-food-based,
That's what we were reported.
okay,
Yep.
Mr. Chair.
And I have reports that show that.
yep, okay.
May I
Appreciate that.
follow up?
Sure, absolutely.
Okay. I know every time I've heard the framing of how this works, we talk about baby food, and baby food sounds so innocent. But when we're talking about food waste, we're talking also about scraps from, can you give me some examples of other things that are considered food waste, or they're allowed as food waste, such as
There's not a requirement on a commercial digester that they can only receive food waste. I mean, to me, that term doesn't mean a whole lot from a regulatory standpoint. What I'm worried about is whatever they put into that system, when it comes out, either as a solid or as a liquid, we understand what the chemical properties of that material are and what the proper destination point for it is. In many cases, it's okay to put different types of nutrients onto our farmlands. They provide value, they provide benefit. What we don't want to do is send things that are laden with heavy metals, with PFAS, and create other problems that we can avoid because we can make meaningful decisions in the permitting process to avoid those risks. And then the other thing we want to do is have systems within our permits to make sure that we're not creating unintended consequences once we do apply that technology or that methodology, to ensure we're not creating groundwater problems or other conditions in the soil that might be bad for plant uptake or other things.
where would heavy metals come from?
It can come from a lot of things. It can come from food, for that matter. Let's be honest, not all the food we eat is great for us, even though I may like it. But when you see concentrations, and again, a digester takes large amounts of stuff, uses bacteria to make it small amounts of stuff. You don't eliminate mass when you do, well, you eliminate volume, but you still have matter that exists when it's done. And so you tend to take things that are diffuse and make them very concentrated if you're not careful. And so that's why our staff spend so much time figuring out what ergonomic rates are appropriate for a particular waste stream to go on that field so that that plant can value from that nutrient value without having a secondary effect.
Representative Wolford.
Thank you, Mr. Chair. Thank you for being here today. Appreciate you. Since we're on that topic of food waste, where does this matter, as you referred to it as the food waste? If it doesn't go through a digester, where does it go?
It depends on,
To a landfill?
it can. I mean, so different industries have different things, so.
But for the
food-
most part, it'd be fair that it
A lot of it can go to a landfill, yep.
So my question is, does the liquid waste stop when it goes to a landfill?
So a liquid waste would not go to a landfill because we don't want liquid content going into landfill. We want to have dry material going into a landfill. Liquid waste typically would go off, if it was being sent off site, would typically go to a wastewater treatment plant. It would either be, or it could be treated on-site and then discharged in accordance with a treatment permit, or it could be land applied, but liquid tends not to go in landfills.
But that comes by the digested, through that process, is that?
I'm sorry, I don't understand the
When
question.
Food waste goes through a digester.
Yep.
Is that where that gets separated, that liquid waste you're talking about?
Yeah, if it's, so Generate, let's use them as an example. They manage their waste. Most of their material as it came out of their system was really, really wet. Fact is, our team referred to it as weak tea. What they would do is they would send it off to a lagoon, and then that lagoon, over time, would settle out some of the solids to the bottom, and then the liquids to the top. The liquids are what they would land apply. The solids would, we just had an example while they were closing out their landfills here, or their lagoons here. They sent a lot of those solids out to the landfill because of the PFAS that was in them.
So if it's not digested, then really all of that stuff still stays in one spot and then goes to a landfill, then to break down where you would have liquid waste. So, okay, thank you for that. Also, you had mentioned earlier that you have communication issues, and that's something that you're trying to work on as a department. What does that mean from you? What does communications problems mean?
Well, I hope we're all honest that we probably all have individual communication problems in all aspects of our life, and a bureaucracy is no different than anything else, and if anything, it's probably amplified. When I say communication problems, one, I want to make sure that our work is transparent. That's something that we're working hard to do. We're trying to put more of our paper records online so that people can actually see them immediately and understand what we do, why we do, and how we do our work. It is part of me explaining why we do our work, just like I'm trying to do today, and being transparent in that and not be defensive, but rather informative. It means trying to be proactive in developing training programs so that people understand what they're required to do and how to best comply with that so that we don't end up in situations where people did something because they didn't know they were they were required to get a permit first and didn't, or if they did submit an application that it was complete. All of those things are things that I am constantly working on. We do LPI initiatives within our team routinely to try to figure out, are there better ways of doing it? We have full staff that we call our compliance assistance team in a division that works actively to set up conferences and training and facilitate technical conversations with our staff to the regulated community.
Aaron, if I may,
Sir.
Just in the interest of time, I have a number of other members that would like to address you with a couple
Certainly.
questions, so
Certainly.
I apologize for having to step in there. But Representative Conlon.
Thank you, Mr. Chair, and thank you for being here for your testimony. I have a comment and a question. One, I want to thank you. In September 2023, we had a very serious sand and gravel pit that was drying out wells in the Ann Arbor Charter Township District that you all came and helped us with and pulled that, pulled a violation for them. So I appreciate that. And then along the lines of what you're discussing right now with PFAS, I do have a farm in my district that was closed down for PFAS contamination. So how does the department support Michigan's agricultural industry while safeguarding the environment?
Big question. I don't know that I can do it in the interest of time in a way that's going to be super clear for you, so I apologize in advance for that. I think it's a variety of things. One, even though it may not be appreciated, I think that the regulatory construct that we try to make as efficient and as unintrusive as possible provides structure to reduce liabilities that those farmers might otherwise do. I mean, there is no way for me to shadow the fact that our water quality in our streams illustrate some of the changes that have happened in our agricultural community as they've enhanced their technologies and work. Just this last rain event, I mean, every rain event you get, it's not atypical to see the water in my backyard change from a clear water to a very, very turbid water instantly because of the runoff that we get. And that runoff often has pollutants in it, whether those are coming from urban areas or whether those are coming from agriculture areas. It doesn't really matter. It's having an impact on our community. So that would be one sense that I'd say it. I think another sense would be we try to be actively involved in talking to them. I'm meeting tomorrow with the president of the Farm Bureau. I know they have questions for us that they want to ask, and they want to try to be able to understand what we're trying to accomplish, and we try to figure out ways that we can work collaborative on that. But it's a really big question. I'm sorry, I'm probably not being as specific as you want, but those are things that come to mind.
No, thank you. I know it's a very big question, but I'm glad to hear you're meeting with the Farm Bureau. Thank you.
Mr. Chairman, if I could add
Really
really
quick,
quickly. Representative Conlon, I know that you have been in contact with our MPART team, our Michigan PFAS Action Response team, and so they coordinate across several different agencies in state government to make sure we have a coordinated response in dealing with all things PFAS. And so Abigail Hendershot leads that team, and I think we've worked on some legislation together. But overall, we do have a really close partnership with MDARD and try to have a coordinated response when it comes to some of these issues that pop up, especially Grostic Farms.
And thank you. You have made yourself very available for questions on this subject. I appreciate it.
Representative Bruck.
Thank you, Chair. Thought you forgot about me. I thought I got my question in early. I guess I was late. So thank you both for being here. Appreciate what you guys do. You obviously have a very, very large job and a complicated job, and I can speak from experience. About this time last year, we had a major diesel fuel spill on exit 5 off 23, and I was out there quite a bit speaking to the EGLE folks, and you guys were doing your job. I mean, that's I commend you for that and ensuring. We have a saying, expect what you inspect. And they were certainly there ensuring that that spill was cleaned up correctly and the mitigation was put in place. And so I see that very important issue being done from your organization, dealing with large corporations, these environmental disasters and things. But from the conversation that we've had in previous committee meetings, there was a number of people, and I'm not here really to argue on the pros or cons of the testimony from previous sessions, but if it seems like a small issue became and exploded into big issues, and maybe there are some personalities involved, that's up for conversation, but if an employee, and you have 1,500 of them, and if an employee makes, puts his feet in the foot in the ground and makes a decision, it seems that I don't want to say the little guy, but that seemed to be a lot of the testimony that we had. It seems like that one decision on the ground was turned into a very large issue, if you will. And understandably, your organization has to back your employees when they make a good decision, and sometimes even, I'm a business owner, sometimes when they make bad decisions, you still have to back your employee or your organization. Is there a time where you have had an employee that made a decision on the ground and you have had to overstep that decision and say, you know what, Joe, Sam, Sally, let Joe Farmer go?
Sure. Absolutely.
Or any examples, I guess?
Yeah, I don't know that one specific example is coming to mind, but as you can imagine, and I'm sure you're in the same spot I'm in, we get a lot of different concerns raised by people about how decisions are being made by agencies, and you follow up on them just like I do. First thing I do is I always try to understand the timeline. How have we gotten to this point? Because you are right, things can sometimes start out small and they get very protracted and they can get very ballooned into a proportion that's not really based on where it started. Second thing is I try to understand what are the determinations that staff are making and are they correct in those determinations. And I will often send things on to those individual supervisors, directors, to validate that they are making the right determination. Let's be candid. Our employees are humans. They make mistakes. I make mistakes. I don't want to deprive my team who is put in a situation where they have to make a lot of scientific and technical judgments, and some of those judgments and our laws often put them in this situation aren't super clear, so they have to try to decide where to thread that needle. And where we've got discretion, those are things that I want to make sure that we're trying to be as consistent as possible on, so I don't end up with different levels of environmental protection or oversight in the east part of the state versus the west side of the state. I want to be able to get to the same answers no matter where we're at. And it sounds very rote and procedural in terms of how our process should be, but in some ways that's how it should be. I don't want to have people feel like they are guessing at what is required or how to get there. So, sure, if there's situations, and that's why I say, come to me, because this is ways that we find out. 99% of the time, I found out that the team is actually in the right place. And I don't say that to be arrogant about the team. Fact is, we had, the legislature passed laws that put in place a permit oversight commission. Okay, you'll probably remember that when that was discussed back at the end of the Snyder administration. That body never overruled my staff on anything that was any substantial, even though a lot of people utilized that process. And it's not because they weren't trying to identify whether or not the staff had done things wrong or not. It was because the staff generally were in the right place. But there are edges sometimes that need to be softened, and sometimes we can do better.
And a follow-up question to that. See, you talked about staffing, and obviously there's big fish and there's little fish on the environmental side, polluters, et cetera. Is there a way to adjust? Because it seems like a lot of the testimony we did have, we'd say those are just, normal Joes. Not all of them, but, they're just people in our community. We've heard people talk about our constituents. I've talked to constituents and farmers that feel this pressure, whether it's meant to be there or not. Is there an effort, or has there been an effort over the past few years of EGLE or MDAR to focus more on those small polluters versus staying focused on the large polluters, if you will? And that seems to be a lot of the issue that we have been running into, with our constituents, especially on the farming industry. Yep. Like they feel like they're being picked on. Is there some way we can, I don't want to say refocus your organization, but make sure you're hitting all the big ones, but maybe not, seemingly attacking the smaller guys,
Yeah.
if you will?
Yes, to an extent. Trying to say this in a way so it doesn't sound judgmental of those that I'm not going to talk highly of, because I'm about to say something positive about the larger industry groups. One of the things I have found over my career is that the larger industries tend to be much more capable in their sophistication for how they deal with environmental management. They have full-time safety and health staff. They have full-time environmental staff. They do a lot more monitoring. They have much more intense requirements around them. And so while a large industry may pose a greater risk if something goes wrong, it's often unlikely that major problems will happen at those facilities unless somebody screws up or some sort of catastrophic event happens. The smaller guys don't have that luxury. They don't have the ability to have somebody full-time. They have to hire a consultant, or maybe they can't even afford to do that. And so they're trying to do everything while they're also trying to just keep the paycheck coming in every day. I get it. Part of that is through compliance assistance and being available, doing more training, more outreach. Part of it is being more clear about requirements. And some of the people that testified over the last 2 weeks were part of that universe where they got brought in a way that they probably have never been brought in before, because we know the problems that are being caused in the environment, that are being caused in our communities, the odors, the water discharges, whatever, and we've got to solve them. And then bringing them into a permitting program for the first time can be extremely difficult for them, and we're trying to work with them. So we build out compliance schedules. We try to make sure that we're addressing these in a case-by-case basis in a way so that we can give them the greatest likelihood of success while still holding them accountable to the standard that we need to achieve. But again, I'd be happy to partner with you if you got specific examples and specific individuals where we can help them better.
I appreciate it very, very much.
Thank
you both.
Minority Vice Chair Miller.
Thank you. Thank you for being here again today in the hot seat. I don't envy you. But I can't ignore the 3 hours of testimony that we heard last meeting from everyone, from farmers to manufacturers. We heard from so many people complaints from on your department, and we've heard you talk about communication issues, and to Representative Bierlein's point, that people feel harassed or there's consequences for speaking out or coming forward. So I'd like to know, what do you have a process to implement, or have you implemented a process to where an individual or a farmer could submit a form, a complaint form, detailing what the issues are, and can you investigate that, or are you investigating it? And because we've heard everything from people being held with, from their will, being taken from different facilities. How is that investigated? What's the process here? I need to be clear on that.
Yeah. Since you brought up the taking out of your will, there was a lot of things as I was listening to the hearing on the 18th, and it was a long hearing, and good for you all for sticking that all out. That was the only thing that I immediately picked up the phone and said, what the hell's going on? That was something that, if it happened, should not have happened, and I can't find any evidence that would suggest that it had the way it was described. I'm not going to say that they're lying, but I can't find anything around it, and if anybody has any details, I'd be happy to look into that further. Haven't said that. Yeah, so haven't said that. If there's anything criminal, I will refer that on to authorities. Fact is,
Just a complaint on how they were, how things were
Yep.
handled and retaliated against, or there's consequences. Is there a form that someone can submit, and who investigates it?
Yep. So we have the ability for people to call into, we have what we call our EGLE line, but people can call in with any questions, complaints, concerns. That gets routed up through management in order to be able to resolve. We have a lot of things that get received in writing where people are raising things. Sometimes they bypass the staff. I get questions from legislative teams routinely, and we follow up on all those. But every complaint and every concern, we either evaluate it to validate it, if it is indeed a concern, and if there is a concern, we try to figure out how we can do a solution around it. Sometimes we can't fix the problem. Sometimes it's just people don't want to be held responsible for the things that the law requires them to be held responsible for, the activities they perform. I can't change that. Sometimes there's things where it's just, this person is difficult to work with. And we've even had reassignment of people at times on different issues just to break up that ice so that there's not that tension anymore and people can get back around a table and be constructive. But I don't know that there's a prescribed for this method of complaint, this is how we do it versus others. But the amount of time that this agency spends trying to get to the answers to make sure that we're doing our job right is significant.
And it's documented.
Absolutely.
Thank you.
So, I know we're running long here, so we have a couple more questions. A couple members that have questions, but I tried to give all the members some time here, but I'd like to just run through a few things with you.
Sure.
That's important to me. One of the big complaints is the idea of surprise inspections, agriculturally surprise inspections. Is that your policy, that you want to do surprise inspections? Or is that just dependent on, forgive me the term, of your individual that does that role?
It's not at the individual's discretion necessarily. There's some programs where by law I have to do them as a surprise inspection.
I'm speaking specifically
Even in
farm
agriculture,
inspection.
even in agriculture. So example, a CAFO permit, a large confined animal feeding operation, those are federally issued permits. The federal government, by my agreement with them, in order to be able to run that program in our state so that we don't have federal authorities running around bothering our folks, they dictate to us specific procedures. And one of the procedures we have to do is doing the ability of unannounced inspections. A lot of times, we will inform people that we're going to be on site. It is beneficial for us at times to have people prepared. They have records ready.
Right.
They know what to expect. And so it is not always a surprise inspection, but we definitely have to have them.
Is it a policy? You operate under all kinds of rule and regulation, right? Federal law, state statute, rules implemented within your organization. Some of the complaints that I received was, depending on who I talk to, I get a different answer. Whether it be a violation, whether it be a compliance, whether it be whatever it may be. What's the term for your individual that goes out and does that inspection? What's the position called?
It depends. I
Okay,
mean,
all right.
okay.
Field agent, whatever.
Sure, call it what you want.
Field
I get where you're at.
Do they have discretion on those rules and those laws that they can implement them to the degree so they desire? severe, less severe? How much discretion do they have, I guess is the specific question. How much
There is,
discretion?
there is some discretion, okay? So for example, my inspectors, field agents, EQAs, whatever you want to call them, they have the ability to make a discernment on site if they find a violation. If it's non-minor, it can be corrected while they're on site. Sometimes they don't even document those. I'm fine with that, right? We're in the business of trying to solve problems, not to troll, people through a administrative process that doesn't benefit anybody. There are some programs where there is built-in judgment. I wouldn't call it discretion, but let me take some of our wetlands program, for example. The statute is very complicated for us, and it's not just the state law, it's also applicable at the federal level. If the federal government was running this program, it would be equally difficult. But in those situations, the way that the law gives guidance to EGLE is it says that everything should be avoided. You should never hurt or harm or impact a wetland unless it's unavoidable. And so there's this whole judgment process that needs to go in where people have to provide us documentation to say, hey, it's reasonable and it's prudent to allow this impact to happen. We make this judgment in terms of whether or not, I see your property, and if you used it differently and you put that facility over here instead of over here, you could avoid them. All of those things end up becoming part of the collective discussion between us and the applicant, and it may feel like it is very discretionary, and it may feel like it's inconsistent because in some ways it is, because that particular program is driven by the site itself, which I go to another site on the other side of town, and it will be completely different with a different solution associated with it altogether. So yes, but where I will be clear is our team does not have discretion to deviate from the law.
Sure, makes sense. Do you have an internal policy that trains and discusses in an ongoing fashion the customer service relationship that you should have established, how you treat customers, how you dissolve heated circumstances? Is that something that's a continual reminder culturally within your organization? You have that conversation with field agents about their interactions, how they should behave, what their role, frankly, is. Are they an enforcement agent or are they a service agent?
They can be both.
They can be both, right?
Yeah.
Okay. So is that an ongoing cultural discussion within your organization?
It is. Could we do better? Absolutely. As you onboard staff, especially newer staff that have never done this work before, a lot of time and mentoring is put into those individuals. So they learn from people that have done this for a long time. They figure out where those soft spots and where those red lines are that they can't cross. There's formal trainings that people go through, and they're required to go through as part of their onboarding process. There's refresher trainings. But this is something we want to do better on. We just brought somebody in to the executive office to work directly with me, and part of her responsibility is going to be to help enhance our trainings for our supervisors and our managers so that we're being more consistent in terms of how we lead and how we direct our staff to do their work.
And if I could add to Aaron's comments, I think that all falls under the broader umbrella. Director Roos, when he started in, I think it was July of 2023, had this Vision 2027 strategy that he's, kind of worked with the executive team and the divisions to kind of outline what we would like to see throughout the next 3 years as we go into the next administration. And one of those criteria that were outlined was how can we be a more customer service oriented department? And so that is something that we're talking about on a cultural level, and we're actively taking steps to try and achieve that.
Good, thank you for that. Art, when decisions are made in the field, is law and science your two guiding principles? Or at times, can opinions by your field agent drive their decision?
It's a complicated question for me to answer in the sense that, let me be real clear.
Do they have discretion to
Our
use their
staff
opinion?
should not be using their opinions in terms of whether the law is valid or not. Okay, so
What
let me
about
draw the line
science?
there.
What about the science?
Yeah, and 30 years of this have taught me that while hopefully science informs policy, the laws are based on policy. They're not based always on science.
Sure.
And so there are definitely situations where we apply laws, because we're required to, in ways that me and my team would argue is not consistent with science.
Well, yeah, that's certainly true, right? It's certainly across the board in legislative acts, right?
Yep.
But the issue that exists, in my opinion, with the department is it's not about what your necessity is, because your necessity is a good thing, right? What you're doing.
Sure.
It's the culture and it's the behavior of your field agents, because that's the term I'm using, okay? You know what I mean when I say
I'm with you.
field agents.
Yep.
Legislation is passed, it comes down to you. Who then writes your rules, your operational rules? Who does that?
Yep. So usually those happen within the central office of Lansing. They're not done by the field staff. Those go through their stakeholder review process. They go through the oversight of the legislature through JCAR, et cetera, in order to be able to come up with the rules that we then implement. There's things that the rules then have, go ahead.
But ultimately, the question is, who writes the rules? It's your
It's-
department, right,
it-
that writes the rules.
It's
through
us.
the process.
And they should be consistent with the law. In fact,
Right.
as I've had a number of people challenge our rules,
Right.
saying that they're not consistent with the law, and sometimes we are right, sometimes we're not.
So you write the rules.
Yep.
Right, so who does the compliance inspections? You do, right?
Sure.
Your field agents.
Sure,
So who makes the determination of the violation?
staff do,
Staff does.
based on their observations.
So when that determination is made, who issues the determination? Who does that come from?
Staff.
Staff. So if there's a violation that's worthy of a penalty, who issues that penalty?
That's a different group that gets elevated through management. It gets approved prior to going to the different group, and then that group, where we call it escalated enforcement, they have a different manager, a different oversight to ensure that we're keeping those that gathered the information and had tried to resolve the process separate from what is now becoming more of a legal proceedings.
But they're staff.
They're staff.
Yeah. Okay.
Yep.
Yeah. So could that involve financial sanctions, like that penalty that comes from that?
Not at the escalated enforcement phase. What may happen within the escalated enforcement phase is we reach a mutual agreement with the party that is in violation in terms of how to settle it, so that none of us have to go through a formal legal proceedings. So you may have penalties that get assessed as part of that assessment, but it's in lieu of legal action.
So when that determination comes down and you're at that point,
Yep.
who does the individual who's having the action taken against them, who do they appeal to?
They have the ability to appeal, well, if they don't reach an agreement with us through our negotiated process, then we would initiate through the administrative hearings process, an ALJ, a process laid out in law for both parties to present their case and an impartial judge make a decision. That's where that decision ultimately is. That has the ability to also get appealed to the circuit court in the event people don't feel like their administrative remedy was adequate.
Okay.
It is out of EGLE's hands at that point.
Yeah. But from everything from writing the rule to making a determination of guilt resides in your, until we get to the appeal outside, resides in your department, right?
Yeah, I mean,
It all resides there.
you all write the statutes. We
Yep.
then try to implement rules that
Yep.
describe how those statutes will be implemented. Sometimes we do permits that describe the specifics about how that applies to the rules. We then go out, do inspections to verify people are following those expectations. If they're not, we will try to work with them and see if it can be resolved without any type of enforcement action. If not, we elevate it. But then you go through all those administrative remedies associated with that.
Right.
And not to diverge too far from where I think you're going with your point, but I do want to, not everything is internal. Yes, we do everything that was outlined by Chief Deputy Keatley, but we do have outside stakeholder involvement in our rules process and often consult with outside stakeholders through our permitting process. And so I do want to emphasize that, it's not necessarily the department unilaterally making decisions with no outside feedback.
Right. Is there a timeline of requirement of notification when you amend a rule for potential permit holders or applicants? Is there a requirement for you to say, hey, there's a new rule we've implemented, it's effective, pick your date? Is there a requirement there?
Yeah, I get where you're going. Let me describe briefly how we approach administrative rules. Candidly speaking, I will not bring the legislature a rule set that we have not run through some stakeholder involvement. It doesn't go well for EGLE, and it doesn't create good relationships with the parties that we're trying to regulate or those that are holding us accountable to regulate those parties.
Right.
So first step for us is to bring people together and say, this is an issue we're trying to resolve. This is why we're trying to resolve it. This is how we want to resolve it. We get a lot of feedback. We try to make revisions. Eventually, we create a rule set. That then goes through the process that's laid out in the APA, which involves a formal public comment period. It involves review by the legislature. You go through all those steps. But we do not create rules in a vacuum. You can rest assured of that.
Yeah, no, I can appreciate that. You know, you're in a really bad spot.
Thank you.
I don't understand why you do what you do, because all indications, both of you, all indications that I'm aware of, that you guys are fantastic people. The problem is that you're running an organization that is too big and doesn't know what the right hand, doesn't know what the left hand's doing. And for you to try to get your arms around that and to try to rein that in is darn near impossible, especially when your power goes from making a rule to convicting the guilty. Like that's a gigantic task that you're placed with. And historically, that just doesn't usually bode well in government. It usually opens the door for behavior of intimidation, behavior of I'm in power. That's why, frankly, I wanted to hear from you, because you're right. You laid it out. All these rules that the legislature passed, but culture in a entity usually trickles down, and I would just ask that you take it very serious that taxpayers and citizens don't like EGLE. You're arguably the most disliked department in the state. That's not a badge of honor. That's an embarrassment. And I'm not targeting you. I'm saying the entity. And so we want to hear from you because we want to hear what it is you're doing to try to fix that, right? The rules and following the legislation, we all get that. What are you doing to fix the culture?
Yeah.
What are you doing to get a favorable attitude from your constituents, who, by the way, are who you ultimately represent? Because who's the victim, right?
Yeah, I appreciate the spirit in which you say that, okay? There are days where I definitely ask myself, why do I do this job? And the answer is pretty simple, because it matters. I've done this my entire career, ever since I graduated from college, and good, bad, or otherwise, it's something that gives me fulfillment at the end of the day because I know what it does for our communities. I have been sued personally because I've issued permits. I've been sued personally because I haven't issued permits. It's the nature of this business, and I get it. All of our staff, I know you're hearing about a culture, and it's easy for you to translate it based on what you're hearing.
Well, I've also
I would be
witnessed the culture,
happy.
but I've also witnessed the culture where
Yeah, well,
I live.
I would be happy to allow you to spend any time you want with any of my teammates that you want, to see their dedication, the challenges that they face on the ground, and how difficult their work is. And I think when you do that, and if you're able to spend some time with them, you will find that everything you are describing about how people may characterize us may be still real, while what you see in them is different than what you've heard. And again, I'm not trying to lecture you on that, but I must tell you from where I sit, it's a very, very different picture than where you're sitting right now.
Right. I appreciate your opinion on that. I have two last questions. Representative Shriver.
Thank you, Chair. I appreciated the question made by my colleague just about the hiring numbers. Just simple. So I'll look forward to hearing what the hiring numbers are. In that same spirit, what percentage of employees in your department work from home full-time?
Right now, our process allows the supervisors to decide how to best maximize the value of our employees. I definitely have probably a third that are full-time in the office doing work because the office environment dictates that the job that they do, that's where they need to be. Most of our team tends, including myself, tends to work in a more of a hybrid approach. I'm in the office 3 days a week, 2 days a week, Monday through Fridays. I work from home. It gives me a ton more flexibility where I'm not distracted in a moment-by-moment basis from folks knocking on my door, and I can get some things done that way. We'd be happy to put some numbers together for you that lists where we're at right now. In fact, I think we've compiled some of that for the legislature already, but we're happy to share that information with you.
Thank you. And along that same line, as far as some of the reports that you mentioned, or referenced, I should say, throughout your testimony here, is that available to the public somewhere that they can access to verify whether or not the numbers are accurate or just kind of see for themselves?
Yeah, if you could be specific about what reports you're talking about, happy to share them, but
The big one is the, I think it was like a tenth of a tenth or something like that regarding the cases that end up going to court or something.
Yep.
That would be really helpful to be able to verify and see for ourselves what those numbers are.
okay, yeah, there won't be a one report for that. I mean, I'm able to look across a lot of data points across my agency, but we can compile some information on you in terms of, you know, how many inspections we do of those inspections, what ones end up in violation notices of those, which ones end up with referrals, et cetera. Happy to do that.
Great, thank you. And how long does it take for your department to process a permit on average?
Depends on the permit. I have some permits that I issue in 24 hours, and I have some that take 180 days. All of our programs have different levels of, it's not like going in and getting my driver's license renewed for the
Yeah.
kind of permits we issue.
But do you have like an average? I mean, you just take all the numbers and then divide them by the amount of time, so you have an average? Do you have an average?
I could give you a number that doesn't mean anything. I could say 60 days, but that's because I'm averaging something that should only take 24 hours with something that should take months.
Okay.
And then coming up with a ridiculous number. So I'd be more comfortable sharing with you our individual program permits and giving you some information around each of those that matter to you.
Would it be possible just to get, you know, an entire Excel of all of the permits that you've processed and the amount of time so that we can open source that and have people dig through it and determine, you know, the averages for the different permits?
Let me work on that, see what I can do.
Okay. And I've got one more question. This is just a yes or no question. Have you done any benchmarking to measure how your department compares with equivalents in fast-growing states like Texas, Florida, Tennessee, just to be able to compare and contrast between yourself and equivalents?
Yes,
And is that something that you can share with us?
I believe so.
Okay, that'd be awesome. Thank you.
Thank you, Representative.
Mr. Chairman, if I can add really quickly. We do send most of our reports to the legislative body, and so you should have a copy of those as they roll in. We also submit our rules to JCAR, and so those are all reviewed by that body as well. And so, you know, if there are other documents that we can provide to be helpful, happy to do so.
Thank you.
Thank you.
Representative Sternagler.
Oh, thank you, and I'll be brief. I just, actually, sitting through the whole thing, I came up with like a few just kind of minor questions, and also just want to say I love what you said, Chair DeBoyer, about following law and science and not opinions, and we absolutely have to do that. And yeah, I mean, clearly, you know, there's some sort of issue, you know, that needs to be addressed because we heard so much testimony, but I'll return to that later. I just have some very small questions first. PFAS, we talked about PFAS. So are we saying that there's actually PFAS in the fertilizer that's being, like, approved and then, like, sent out?
I can't speak to fertilizers that are sold on a commercial basis in terms of what's in them and what's not. What I regulate are waste streams that are tried to be used for a beneficial use within the agricultural community.
So there might be PFAS, like, going into those soil
On-
fertilizers that
You know, PFAS doesn't occur naturally, so only if there's something introduced into that process that would result in a waste stream that would have it. Again, I can't answer that in specific for you.
Okay, I was just curious about that. And then also, we talked about the whole process, you know, for the permitting and how it goes, you know, if it gets escalated and whatnot. Once it's finally decided, I think you may have already said this, but is there an appeals process? after that?
On the permitting side?
Yeah, like.
Yeah, if somebody doesn't like a permit outcome, whether they are the entity that received the permit or somebody that represents a client that they think could be impacted by a permit, there's the ability to challenge a permit and have an impartial judge review that.
Okay. And then in reference to Vice Chair Miller's questions about the complaints and like, is there a process for those and documenting them? I guess my question or concern around that is that, if we did want to look and see, what those were and what the outcomes of those were, it sounds like those are available, like they're probably subject to FOIA or something,
Yeah,
and they're
all-
internally documented.
Yeah, this is the lovely thing of working in an executive office. You have the privilege of everything you do becoming foiable. So, yes, any document that we have is foiable, with the exception of if somebody has a business confidential piece of information in an application they submit.
So
But
when someone complains.
Sure.
That is something we could access. And then just, I'm not really sure this is a question, but I've actually found the structure a little bit hard to follow because we had EGLE today and we had all the other testimony and hours worth of testimony the other day. So it kind of took me a while to connect those in my mind. I don't know if maybe in the future we can kind of just have them the same day, if at all possible, just throwing that out there.
The whole day in this room then.
And also just in regards to kind of the big picture and the structure of this and what we're actually trying to do here. Maybe this is a question for you, Chair DeBoyer, but is there like some I don't know, like framework for what we were trying to accomplish here, and have we accomplished it? Is there some sort of recommendations that we are going to make to EGLE at this point, or
Potentially,
what
sure. That
is?
potentially could be, yep.
Because I mean, we
That's-
can
that's our whole
certainly
process.
listen to people complain all day, and we can hear responses, but without having some sort of structured, idea of like how we can actually improve this. And I'm not saying we need to do that today, but that's.
Yes, ultimately, the oversight's role is to look at these things. It doesn't mean there's criminal things going on. It doesn't even mean there's violations going on. It means there's processes perhaps going on that need to be changed. And as you've noted, some of those processes are legislative acts, right, that we may have to look at to allow them to maybe be a more customer-oriented, theoretical, right? That's ultimately what we do, and that's why hearing what the constituents have to say, which were the people that testified,
Sure.
and hearing what EGLE has to say matters. Then we have to make we have to ruminate on that, right? And we got to
Sure, yes,
decide.
because I think
like,
we all agree that
how
we
do
need to
we-
have a
yeah.
permitting process. It needs to be based on law and science, and that, EGLE is certainly, doing their job with the permitting process. They have processes in place, yet there's still some issues with how it's being carried out, or how if people don't like it, and maybe we just need to figure out a way, so that we can be assured that, people are getting the service that they want. Because without, extensively deep diving into every single case, I mean, we don't really know, are people just complaining because they don't like that they didn't get a permit? Or is there actual, I mean, we'd have to investigate every single case, which I don't know that, you're suggesting that we actually do that. But putting processes in place, like I think you're referring to ensure that, we don't have situations that, like the ones that are being alleged, is probably what we want to do. Anyway, sorry, I don't want to make this even longer, but I just like to have a goal when we're spending so much time on, a
Thank you,
particular
Rep. Sternberg.
topic.
Appreciate you guys taking the time.
Thank
Thank you
you.
very much. Thanks for the information. Very helpful.
Anytime.
Enjoy the rest of your day. We will get out of here. Representative Wagala moves to excuse absent members. Be no objection.
Sorry, sir, you only have 8 people present.
So we're already out.
Can't move.
Yeah, true. Good point. Strike that. Being no further business before the committee is adjourned.
Sorry, we lost.
Thanks, I didn't